I am a professor here at the College of Law and also a member of the Speakers Committee here at the college. As we gather here, we acknowledge we are on Treaty 6 territory and the homeland of the Métis. We pay our respect to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I would also like to acknowledge McKercher LLP for being the sponsor of the College of Law's lecture series. Their support allows the college to continue to present a wide range of informative, educational, and entertaining speakers to the law school and its surrounding community. So thanks to McKercher LLP and for everyone that is attending. Given the topic of today, I thought I would put in a couple of plugs for a couple of initiatives that we have done at the law school, I guess fairly recently. The first is the faculty blog. We launched a new blog this summer. It's at words.usask.ca/UsaskLawblog / sorry, I think I have to add those backslashes. And one of the more recent pieces that's on the blog is authored by Professor Keir Valance on the effect of recent changes to the Saskatchewan Employment Act. So if you're interested, you might want to catch his blog post on that. The Saskatchewan Law Review, a law journal that is edited and created here at the College of Law, is also starting its own law review blog. It will be launching soon with original writings by members of the student editorial board of the law review. So we'll keep you posted on that, but that will be coming to you soon as well. And at this point, I'd like to call up Michael Crampton. Michael is one of the managing editors of the Saskatchewan Law Review, and he's going to talk a little bit at this time and introduce our speaker.
Thanks, Professor Haven. Yeah, I just wanted to give a little bit of background on the genesis of the idea of inviting Chief Judge Crabtree here today. I think we can all agree that social media generally is changing the way that we interact, and inevitably that this will be felt in its interaction with law. And there are a number of means that we can see this happening already. Last year there was the Toronto Twitter trial. I don't know if people have ever read that decision, but it was actually a case of criminal harassment through Twitter that led to a decision and having to define about hashtags and all sorts of things of that nature. I think students here, even faculty, were glued to their computers during the Gomeshi trial. The idea of journalists doing live tweets from inside the courtroom, the instantaneousness of commentary and feedback, including legal academics from here at the college that students were following. And that's being even manifested in other ways too, such as SSRN, how fast academia can respond to changing issues and changing questions of law. But then there's also another whole side of this where there's the harms that can come out of it. So we have new problems or new dimensions of old problems that are evolving through the digital technology. So problems like revenge porn, hate speech online, identity theft, and questions of defamation through identity theft and of that nature. So I think we're very fortunate today to be joined by a jurist who has embraced new technology, or has at least gained a reputation for that, to give a perspective from inside the courts. I would argue that provincial courts are very often, they're the ones on the front lines of the justice system. Maybe they're even dealing with these questions first. A lot of the instances that I mentioned were at the provincial court level in different jurisdictions throughout the country. And it's notable that the BC Provincial Court has been what's called the best court Twitter account in all of North America. I've done all sorts of exciting initiatives. There's been other blog posts about how good that Twitter account is. So I encourage you, if you have a Twitter account, to give them a follow. They're very interactive by all accounts. Chief Judge Crabtree himself, by way of introduction, was born in England but raised in the Fraser Valley of British Columbia. He received his BA from the University of British Columbia in 1978 and a Bachelor of Laws degree from the University of Victoria in 1983 before being called to the British Columbia Bar in 1984. Before his call to the bench, he practiced with an emphasis on criminal law and civil litigation, and was eventually appointed a judge of the provincial court in 1999, and subsequently appointed chief judge in April of 2010. So it is my pleasure to introduce the Honorable Thomas Crabtree, Chief Judge of the Provincial Court of British Columbia.
Thank you for that kind introduction. It's a great pleasure to be back here at the University of and at the law school. It holds a particular warm spot in my heart, as my daughter had the opportunity to attend to the Indigenous or Native Law program when about 7 years ago now. And that was my first exposure to the university when I brought her out from the West Coast. And even at age 23, and then the prospect of leaving her here for the summer, she was still my daughter, and it was still difficult to do so. But I enjoyed the time that I had while I was here, spending it with her and at the school. The invitation to join you here today, in part, was to deliver a presentation on social media and the law. And the invitation went on to read, this is from the organizers. We had initially thought that October 31st might be a suitable date for such a presentation. I'm not entirely sure what the organizers had in mind when they suggested this particular date, but I can indeed assure you that it's a treat to be here and spend the next hour with you. As many of you are aware, I hosted a Twitter town hall on April 14th, 2016. And to be quite frank, it all came about rather innocently. I had talked to the representatives of the CBA as to what we intended to do for Law Week in 2016, and perhaps flippantly at the time throughout the prospect, well, why don't we try a Twitter town hall? And I think that as soon as you mention that to a PR representative, they will never let that concept die. And what I thought was a casual conversation turned out to be a firm commitment, and a few months later, here I was hosting the Twitter town hall from our office. My intention today is to fit that recent experience of the Twitter town hall within our court's efforts to engage the community, litigants, and government in terms of what the court is doing in a more transparent way through the use of technology. And it's these efforts are motivated, at least on my part, on the belief that it demonstrates an openness and a transparency that enhances the confidence in the court and the system of justice more generally. In thinking about that, and I think that one of the ideas or principles that's always motivated my thoughts in this area is what Jeremy Bentham said in the 18th century when he stated, "Where there is no publicity, there is no justice. Publicity is the very soul of justice." And I believe we need to reflect on new and respectful ways in which to inform and engage the public. So today, my brief comments will be structured along the lines of why our court got engaged when it did in terms of technology and social media, the forms in which we engaged, and talk a little bit about the Twitter town hall, since that seemed to attract some attention earlier this year, and then just to reflect on where we've come and where I think we as a court are going. So the culmination, if I can put it that way, to this point in time, and being the Twitter town hall, was the product of a number of forces that were at work when I first became chief judge. You've heard that I was appointed in 2010, and I became chief at a time when there was a fairly significant reduction in court resources in the provincial court in the province of British Columbia. Traditionally, we'd had 143 judges on our court, and we were 16 judges short and had been that number short for approximately 2 or 3 years. And there had been an increasing dialogue, and perhaps I think it's fair to say an increase in tension in terms of why these appointments weren't being made and why replacement to the court complement was not occurring. Because of that, I thought that the way in which to engage in a conversation with government, as opposed to do it through the media or be seen as an advocate, was to prepare a body of material that would then be placed on our website, which would inform the public and those that cared to go to look at that information, so that they could understand the difficulties that the court was facing. And as a result, this is another iteration of our website, but at that time we posted and made fairly visible and made it be known that there was information that set out, in fact a report setting out the issues the court faced, the problems with the lack of judicial complement. At the same time, I believed it was important for the public to know how the court was being administered and by what measurement the public, we believe the public would be interested in knowing how well the court was performing. So commensurate with that report that I had prepared, we posted on our website a number of brief reports with respect to the timeliness of matters coming before the court. In other words, setting out where the delays were, what the difficulties experienced as a result of the reduction in the court complement. And those reports have been since published on an ongoing basis, a regular basis up to the present time, with the view that the court has an obligation, as being a servant of the public in my mind, to at least indicate through annual reports and in this case, by going to this site here, being able to see a number of reports which set out the current status of the court in terms of how it's meeting the demand of those cases that are coming before it. So that was the first issue that forced us into thinking that we needed to provide a respectful way in which we could engage in a dialogue where we could present information to the public. It was then up to the public to take whatever steps they deemed appropriate, including the media, in terms of reporting out on these particular issues. The second, of course, was the difficulties that were being experienced across the country in terms of access to justice, and the belief that there needed to be a better way in which to communicate and to provide information about the court. It seemed to me that one of the issues as it relates to access to justice is the lack of information, particularly for those that are engaged in the conduct of their own litigation, self-represented litigants. And so we engaged in a fairly aggressive series of activities which then began to put on our website information that would be informative to self-represented litigants in terms of how to conduct themselves when engaged in processes, particularly the criminal, family, and civil processes that our court has jurisdiction over. And finally, I think the third force was the realization that these other factors were contributing to what some had suggested was a lack of confidence in the justice system. It got to the point in British Columbia where in 2010 the CBA commissioned a report to investigate that very fact and for a professor from the University of Simon Fraser to develop a strategy as to how the justice stakeholders in the province could engage in a way to enhance or increase confidence, the level of confidence in the justice system. And so Professor Boyd explored that opportunity and came up with a series of recommendations. The primary one, which probably comes as no surprise to any of us here, was to increase the way and the degree to which the public is educated about the justice system. So it was really that factor in concert with the other two that we felt that we needed to adopt a more public presence, and that's what gave rise to our belief that we needed to engage with the public, with the litigants who were appearing before our court, and with government, and it was determined that the way in which to do so was to provide a more enhanced, more robust website with information that is contained in the various headings that we have now developed. So the redesign and reformulation of the court's website was first and foremost, and in particular, this resulted in what many courts are doing, ensuring that judgments are posted in a timely way, but also creating e-news, which are a series of articles that are published every week. These articles are written by judges of the court. They're contributed to by individuals who are participating in the justice system, participated by law students, and I'll give a couple of examples in a moment, but they are 800-word articles, which, as I say, are posted each week. And if I go forward here, you will see that we invite those that come to the website to subscribe to the e-news. So these e-news articles are not intended to be legalese, or written in legalese or legal documents, but more some relate to processes about the court, but they also talk about the court and those that are involved in the court, particularly judges and judicial justices. So you'll read articles that talk about what to expect when attending a settlement conference. You'll read about what Judge Mackay did when he went on the last Northern Circuit, and you'll see a series of accounts of the communities he went to and the series of engagements that he had when he was in the North sitting on that particular circuit. So they're posted each week. You'll see here that we set out relevant news of the court, but each week you'll see the article appear. It'll be delivered directly to you if you subscribe to the service. And as you'll see, the most recent one relates to why did the Guyanese judges visit BC Provincial Court last week. We had the Chancellor of the Guyanese Court of Appeal and a number of other judges and justices attend to talk about issues that they have in terms of delay. And that newspaper account talks about the interaction and who is involved. It's a way in which to familiarize the public with the work of the court, which would otherwise go essentially unheard unless a specific effort or attempt was made to contact the local media, to engage the media in which to deliver the message. These articles, while written by many different authors, are all overseen by one person who then essentially acts as an editor. That person is a retired judge of our court who's had some previous involvement with the media. And we're fortunate in that particular, or in this instance, to have her and to have her experience that she has committed to sharing with us over the course of the next year. The other way in which we attempt to become involved is through the use of videos, which are also posted on the website. You'll see here that this relates to a video where the court was involved in Law Week, again the CBA week, where it's designed to create awareness for about the justice system, about the legal system in British Columbia. On this particular occasion, we went to a small community on Haida Gwaii, which had never experienced a law day event before. They have a small courthouse that is opened approximately one week out of every 3, and we basically invited the high school to attend and participate for the afternoon. And in doing so, they had not only the opportunity to go through the facility, but also to be engaged in a discussion with various individuals involved in the justice system, including police, probation, Crown. And they had an opportunity to speak to lawyers and talk about various aspects of the different participants' career in the justice system. It was interesting, and if you look at that video, what struck me is that one student who talked about having walked by that building for about 9 years, that she had been on Haida Gwaii, had always wondered what was inside and had never gone in. To me, that sort of inaccessibility is just, to be frank, I think we need to do a better job. I think that the provincial courts across this country offer a great wide range of diverse services to the public, and I think that we need to, for lack of a better expression, to get the message out and to show the public what it is that we do and how we do it in a daily basis throughout many communities, certainly across the province of British Columbia. 3 other things that we did while we were engaged in this process of becoming more engaged with the community, and one was development of these videos and other videos in conjunction with the Justice Education Society, and posting those on YouTube so they're accessible. When I recently went to YouTube and looked at all of the videos that we had, it struck me that those don't acquire a lot of traffic in that form, and that there needs to be a way in which to sort of entice people into the work in the terms of the video pieces that are put together. We need to entice or attract people in a different way, and I think this is one of the initiatives, is to post some of these videos directly on our website. This then led us to sort of how we could further engage with the public, and brought us to acquiring a Twitter account in about 2011. And to be honest, I have to confess that I didn't know a great deal about Twitter then, and I don't know a great deal about it now, except that it's an effective means of communicating, as long as you can do it within 142 characters. And so since about 2011, as I say, we had that Twitter account. I'm told that we had approximately 3 followers for the first 2 or 3 years. One was a media outlet and 2 restaurants. Now, for the life of me, I can't think what the restaurants had in mind by wanting to follow what the provincial court was up to, except they thought perhaps we posted our breaks or something and they know when to get ready for the rush. I don't know. But in any event, it really was, it simply sat in that form until we started in about the beginning of 2015 tweeting out some events relating to the court, and also retweeting information that we had acquired from other justice systems participants. But when it really when it really took off was when we started discussing this idea of hosting a Twitter town hall with the chief judge, and it was premised on the idea that we would attract a certain amount of attention to the concept because it was new. I have no desire to appear in the limelight or in the public light any more than I need to, but I recognize that we could use the vehicle of the office of the chief judge to attract a certain amount of attention, to possibly engage with those members of the community that wouldn't otherwise engage through the more traditional means. And it was really, that was the motivation around the idea of hosting this event. It was hosted during the Law Week in 2016. We do a number of events with the CBA and have done so for a number of years. We participate with Ian Hannamansung and tape a session with high school students where they come into a forum much like this, and we tape it, and there are high school students who come from the Greater Vancouver area, and they can ask any question they want of the three chief judges who participate. So we have ventured out in other ways previously, but this year we decided, in addition to those other events that we participate in, was to engage in the Twitter Town Hall. And I have to say that after, as I said in the introduction, of sort of somewhat flippantly throwing it out to a person at CBA, the closer we got to the time, I really started to wonder what the heck was I thinking when I ever made that suggestion. And I would like just to show you a few slides in terms of taking you through that process. And so this is my attempt to show you how judges traditionally speak and write in rather large pieces, and I'm now having to bring this into the context of how am I going to say this in 142 characters. And that, I have to say, caused the greatest angst in terms of getting ready for this particular session, where I responded to the questions that were coming in. I think what I'm going to do is quickly go to this. So this was set up with a bit of a methodology in mind, in that we had certain goals, and that was to increase the awareness of the provincial court, certainly not to increase the awareness of the chief judge of the provincial court. We saw the obligation to inform people and to provide direct access, we thought was critical, because we say that the justice system needs to be open and transparent, and we thought this was a way of demonstrating it. And at the same time, by that direct access, providing access to justice. So we would, this picture depicts the actual day and the event that occurred. You'll see me hiding at the very end on the right-hand side. We had a number of people that were here to participate with us. There were those from other organizations, the Law Society and the CBA, who were retweeting information and responses as I engaged in them. And we had the person on the left at the forefront is the individual who's the retired judge of the court, who I've asked to spearhead this activity as we move more into the public domain. So this is how the process worked, in that there were a number of people involved, as you saw in the picture, but ultimately all of the responses, either those crafted by me in conjunction with others or those crafted by others, came through me, and then they were sent out. Here's a few sessions or tweets. First of all, we didn't want to set out that we only were going to deal with, or we didn't want to say no inappropriate questions will be answered. We thought we'd turn it around and just say we're ready for your thoughtful and constructive questions, not to assume that anyone would be asking us an inappropriate question. And then the next tweet is how we at 1:02 indicated that we were ready and open for business on that day. So in 2 hours we had 72 questions and provided 100 responses. So it may not seem like a big deal, though it seemed to certainly attract the attention of a number, either through the direct access or through the retweet. And this is a sort of a schematic or a visual description of the day and the activity of those 72 questions. So what struck me about this is the power of this medium through which we can create access and inform people with respect to the work around the justice system. So those at the end, a number of comments that were provided. The one that struck me, I think the most, was from an Indigenous organization that said, "Thanks so much for Twitter Town Hall and for being open to questions." That to me sort of signified the whole day in terms of what we were able to do. And what I hope is that through this process we have formed at least some linkage with another generation and with others that would normally not come through the more traditional means to learn about justice, to learn about the provincial court, and that they'll return to our website or continue to be engaged in exploring ideas that obviously confront them in a very real and regular way in the community. Following the town hall website, or the Twitter town hall rather, I can say that our website has seen an increase in usage. There's approximately, last month there were approximately 25,000 users. There were approximately 85,000 pages viewed. I'm pleased to report that having gone from a lowly number of 3 followers, we've now increased that somewhat, and we're up to 750. Not a big number, admittedly, but at least 747 than we had before. And I think that we had our tweets in September were delivered to 80,000 Twitter accounts through retweets. So I think the power of this process is it's not just the followers, but it's those then that are sending it on. So a number of our followers are institutional followers, and they perhaps have much larger followings, but we're able to sort of parlay that into getting the message out to a much broader section of the community. So where do we go from here? The Twitter Town Hall was started as a sort of a one-off, other than we have retired Judge Routhwaite assisting in doing some tweeting out of court news and retweeting of information. I suspect that the Twitter Town Hall will become an annual event, but I don't see it perhaps necessarily progressing beyond that. We're looking at tweeting out when decisions are released. We have a number, as any court does, a number of high-profile decisions, and one of the ways in which the accurate information can get to the hands of the traditional media is rather than simply being either in the courtroom and listening or simply hearing about it, by that information being passed on, we can deliver it at least to them so that they know where the written decision can be found. And of course, like many courts across this country, there are decisions that are posted electronically virtually as soon as they're released, and we have a process in place that ensures for those highly sensitive ones that they are posted in a timely way. Tweeting would enable that to ensure that those in the media would have instantaneous notice of that. We see the great use in videos, not only as teaching tools for self-represented litigants, but also just to provide, again, general information. If you go to YouTube, you'll see a fairly interesting video on our First Nation court. And it's a reenactment of that court, but it actually has all of the individuals that were originally involved in the process, and it takes the public, or it takes the viewer through each step of that process. And so in a way in which that individual doesn't need to go to the court where the First Nation court operates on a monthly basis, they can do it by going to the web. It strikes me that this is a forum that once we engage in this type of process, there's no going back. And I think that we're careful in an effort to try and engage in a respectful way with the public. As I say, I don't view this necessarily as an advocacy piece, unless I'm advocating simply information for the public and for those that are interested in finding more about the justice system. I think that I did want to just talk about a couple of concerns that I see, and that is, and I think it's why we have reached this point by this long progression since about 2010 of becoming engaged in a gradual or incremental way, in which led to the town hall or the Twitter town hall. And that's because there is a loss of anonymity when you engage in this process, and as I say, there is no going back. One of the big concerns I have, well, there's two. The impact on the court's impartiality as an institution, and I think that's why we're very careful, even though prepared to engage in these new ways in which to deliver and engage. I think that we are very, in my mind, slow because we want, in adopting them, because we want to ensure that there is no impact on the court's impartiality, that the court is still seen as that fundamentally fair, impartial institution where people come to obtain a just resolution for the issues that bring them before the court. The other, of course, is, and maybe it's just my fear, but it really stems from the fact that you can do a number of good events or good deeds, but it only takes one misstep, which is then going to destroy all of the work that you have done. I live in fear of that, and I think we've seen a number of examples. One only needs to look at the election process down in the United States to know where that can occur. So, as I say, I think that caution needs to be exercised. We don't accept this without reservation, and I would also acknowledge that we're probably further out there than many of my colleagues are, and perhaps some have said ever will be. And yet, it struck me that, and perhaps I'll end here, and just so I can deal with some questions, but it struck me that I think Richard Susskind, the lawyer and futurist, sort of hit the nail on the head when he said that legal institutions and lawyers are at a crossroad. He claims, and they are poised to change more radically over the next 2 decades than they have over the last 2 centuries. If you're a young lawyer, this revolution will happen on your watch. So, first of all, he may not be saying a great deal when he says radically changed and over the last 2 decades, or 2 centuries rather, because we've been moving at a very slow pace. But there is no question that the way things have been moving and will continue to move, we're on the crest of a wave of engaging in entirely different ways, not only in terms of informing the public, but in the way in which our legal institutions deliver justice. You only need to look at the work being done on online resolution. You only need to look at how the access to justice work of retired Justice Tom Cromwell looks at the delivery of services for those in the realm of civil and family law. These are not now seen, in my mind, as legal issues. These are seen as social issues of which there's a legal component. So we're part of a much larger system now in terms of resolving problems, and I think that we need to engage the technologies with those that are going to lead us into the future, and that means the law students, and that means young lawyers, and I think we need to harness that, their ideas, their energy, and to say how can we in a respectful way continue to push the engagement with the public forward in a way in which they will tune in to us, as opposed to me simply standing up here and delivering a lecture. There needs to be, we need to engage in these new technologies. So those are a few thoughts that I have, and I'm happy to take any questions.